Good afternoon or morning, depending on where you are. This is Sharon Dietrich from Community Legal Services, and welcome to Bringing Automation to Record Clearing in My State. Every time that CLS brings you a webinar, no matter what the topics or the speakers, we get questions like, can we do automation in a state with decentralized court records? What would we have to do to improve our data before we can pass a clean slate bill? These are questions that often I have not put to our speakers because, frankly, I think they'd be confused by them since they often did not match their area of expertise. But your questions did make me finally figure out that we needed to present a webinar on this topic. So hopefully we will answer a lot of those questions in the presentation today. If not, certainly in the Q&A afterwards. We're happy to bring you experts who can answer all the technical questions that you have. Both Noella Sudbury and Code for America have been key players in the Clean Slate spread across America since its earliest days. Noella is the owner and founder of Sudbury Consulting, LLC, and has more than 10 years of experience in criminal law, data-driven policy, legislative strategy, and project management. Shortly after Pennsylvania passed our Clean Slate bill, I got a cold call from somebody in Utah wanting to know the details of how we did it. That was Noella, who from her perch as the senior policy advisor for criminal justice in the Salt Lake City mayor's office, led a successful campaign for Utah to become the second state to pass Clean Slate in 2019. And I'll note that that's even a redder state than Pennsylvania is. Despite Noella's relatively short legal career to date, she has been much honored, including by Utah Business Magazine as the 2019 Utah Woman of the Year. That's pretty impressive. On Clean Slate, she has since played it forward by supporting campaigns in other states, and she is now working on implementation in Utah practically as we speak. Also speaking today are Michael Cowden, he, him, and Shayna Cummings, she, her, who work on the solution engineering team at Code for America. About the time that I was first talking to Noella, I was paid a visit by Yvonne Silva from CFA, who just happened to be, quote unquote, passing through Philadelphia and wanted to meet me. We had a good chat that day, and CLS has been working with CFA ever since on Clean Slate issues. CFA has played a central role in supporting Clean Slate campaigns around the country. Michael and Shayna work alongside state partners to help pass and implement Clean Slate legislation. So far, they've had experience working with a dozen different states, providing a technical perspective on Clean Slate feasibility and impact. For those of you who do not know CFA, I'm delighted to make this introduction in this webinar. Now, just a few announcements before I turn it over to the speakers. First of all, please put your questions in the chat and we will address them in the last third to quarter of the program. Also, coming up in the National Record Clearing Project, I wanted to know that we still hope to announce a webinar on a nascent movement of newspapers to mitigate harm to former defendants by changing or removing stories or mugshots. So stay tuned for that. We also anticipate bringing a Fair Credit Reporting Act session from one of the leading members of the plaintiffs' class action bar, which I think you'll find really interesting. Finally, CLS has just been cleared to bring you the third year of the National Record Clearing Project. Thank you, Kellogg Foundation. Please reach out to us to let us know anything that we can do to be of help. And I'm sure you'll be hearing from us with some surveys over the next couple of months. Speakers, take it away.
Thank you so much, Sharon, and thank you all so much for joining us here today. We're really excited to be here. As Sharon mentioned, my name is Shayna Cummings, and I am a staff solutions engineer at Code for America. A little bit about Code for America. So we're a national, nonpartisan, nonprofit organization. And we really see ourselves as problem solvers, looking to show that with the mindful use of technology, government can work well for all people. And our goal is a resilient government that equitably and effectively serves all Americans. As you may know, Code for America is a steering committee member of the Clean Slate initiative. So our Clear My Record program that both Mike and I work on is a program where we work with both community partners and organizations, as well as government agencies, IT stakeholders on automatic record clearance. And our goal is really to make automatic record clearance where all eligible records are cleared automatically without burden to impacted people, the standard across the country. We see our perspective as our role as bringing a technical perspective so that the policies that get passed are both feasible and implementable, as well as impactful. And our vision, and I'm sure many of you also share this vision, is a country where people that are impacted by the criminal legal system are able to actually pass a routine background check so that they can qualify for jobs, housing, and educational opportunities from which they are typically excluded.
Hi, everyone. I'm Noella. As Sharon mentioned, I now own my own consulting company. But prior to that, I'm an attorney by training. I practiced as a public defender and as a private criminal defense attorney, and then went over to the policy side to Salt Lake County and led Utah's successful campaign to pass Clean Slate in 2019. I am currently leading Utah's campaign to successfully now implement the law that we passed. And implementation success to us in Utah looks like these four things: that our law is fully implemented and that the records actually get cleared, that individuals who have those records are aware of the law and how it might impact their lives, that eligible individuals take advantage of the law, as Shayna was saying on the last slide, to access greater opportunities, and that the voices of directly impacted people are elevated to lay the groundwork for future expansion and reform for those who are not yet Clean Slate eligible. We hope to, in Utah, do something similar to what Pennsylvania has done in adding, once we have this framework built, adding to that class of eligible people that don't have to go through the burdensome petition-based process.
Thanks, Noah. So our agenda for today, we're going to start with a little bit of a high-level overview about automatic record clearance in the US and where we're at. Then we'll be diving into a discussion about how you can clear records in states that have both centralized and decentralized court systems, offering some examples for each of those. And then we're going to be talking a bit about best practices for data and how to deal with imperfect data. And then finally, we'll open it up for questions. As Sharon mentioned, she'll be moderating, so please feel free to pop those in the chat as we go. So first, let's start out with a brief overview of where we're at with automatic record clearance. So at Code for America, we worked with over a dozen states over the last 4 years that are all in varying states of writing policy and passing bills and implementing Clean Slate. So you can see these highlighted on the map. There are also some other states that we did not work with that have Clean Slate laws on the book as well. But right now, there are 5 states where Clean Slate bills have been passed. And we're actively working on campaigns in 7 states right now, and there's many more in the future. So one of the really exciting things about this map is that you can see this spread of different types of states, sizes and geography that are engaged in this, and we're seeing so much momentum in this space, which is really encouraging. One of the most important learnings I feel that we've had so far, at least on the consulting the solutions engineering side, is this idea of when it comes to automatic record clearance, we don't want to just create the petition-based process for automatic. So what you really want to do is kind of get back to what data do you have, what systems do you have, and what limitations do you have, and actually embrace all of those things as you design the policy. So put a pin in that, we're going to go into that later. At a very high level, when we implement automation, there are 2 steps. The first step is to actually determine who is eligible. So which individuals, which charges actually qualify for record clearance based on the policy. And then the second step is to then update the records of those individuals. And this is not as easy as necessarily hitting the delete key. It may involve modifying the disposition, flagging the record as expunged, or sequestering it in another location digitally. But it is very doable. The next question we have to ask is, where do the records actually live? There are two sort of main sources that we look at when we think about implementing automatic record clearance. So the main system that we think about is the criminal history repository. So this is typically owned by the state police, and this is the system that when you are arrested and fingerprinted, your information goes into. And one of the advantages of this system is that the records in it are linked to individuals, typically through fingerprinting. So if we're trying to do an eligibility determination, we can get a complete record of all the cases for an individual. One of the downsides of this system is that it may only contain fingerprinted cases. So in some states, there are cases, especially for lesser offenses, where a person is not fingerprinted and they're not actually present in the repository. So it may be an incomplete set of data. It also may lack sentencing information or incarceration or anything like that. So if you have some part of your policy that relies on that data, it may be a bit of a challenge to use the state criminal history repository. The other system that we can look into is the case management system, or CMS, which is owned by the state court. So this is going to have, of course, every case that reaches the court. This is primarily a workflow tool for the court, but it's going to have every case. However, these case records are not always linked to individuals. So that is kind of a downside. You might have to actually look up an individual via personally identifiable information, and it may be imprecise or incorrect. One of the positive sides of using this data is that it in fact includes lesser charges, oftentimes that sometimes might not be in the repo. And then it also is going to include more accurate disposition information because that's being entered at the time of sentencing. So when we think about court data, there's kind of two main buckets to how it might be organized. The first bucket is a centralized system. So this is, you're having all of the data from all the different state courts in one system, and it is accessible and sort of manageable from one centralized place. So these are some examples of states, Utah, Connecticut, New York, Oregon, and Delaware that have centralized court systems. The other bucket is a decentralized system. So this is where each county, municipality, even sometimes localities, has its own system for storing and managing court data. So some examples of these states would be California, Louisiana, Texas, and Michigan. One little nuance I do want to call out is that centralization is somewhat of a spectrum, not necessarily a binary. So sometimes even in a centralized state, you may have other courts that are outside of the system. So especially like municipal or justice courts may not be plugged into the main CMS. So Noella is going to take us through an example of a state with a centralized system, which is Utah.
Great, thanks. So I've outlined here what Utah's Clean Slate implementation process is, but before I get into this flow, it might be helpful to talk about what happened with Code for America and our partnership in Utah there. So Utah passed Clean Slate in 2019, and it was supposed to go into effect May 1st, 2020. But then COVID and the courts were completely slammed. But we were lucky to have great technical assistance from Code for America to help us identify eligible records. And that work has been going on the past year. Their preliminary analysis is complete. They've used our court data to identify all eligible cases. As Shayna was saying, we have a centralized court system in Utah, so all of our courts statewide are using the same case management system. The challenge is it's not a person-based system, it's a case-based system. And so before we can even talk about record clearance, Code for America had to help us match up those cases to an individual, because in Utah, the way our law is written, you're looking at the individual as a whole to see if they qualify for Clean Slate. Laws are structured different ways. You don't have to do it that way. That's just how Utah's law was written. And so step one was to do that case matching into people. And then step two is, once we have those people, identifying what records those people have that may or may not be eligible for Clean Slate. There will be people that are fully eligible, their whole record will be cleared, and then there will be people who are partially eligible, who have Clean Slate eligible misdemeanor cases, but a felony record that still has to go through the petition-based process. So that great work is complete. It's been wonderful to work with Code for America in Utah. And they have estimated that over 200,000 people across Utah are going to be Clean Slate eligible. So that is very, very exciting. We are now validating that work with attorneys. So we are taking that work, and attorneys are reviewing randomly selected cases to see if attorneys would come to a different determination than the computer tool. So that's just where we are in Utah and all of the great work that has happened so far. So once that work is done, this slide really talks through how the records are actually going to be cleared. So Code for America has helped write the code to identify eligible cases. That's step one. That's using court data. Once those cases are identified and our validation work is finalized, on a monthly basis, eligible cases are going to be sent to prosecutors. This takes us to step two. Prosecutors then have 35 days to review all of the Clean Slate eligible cases and have very limited objection rights under the statute. So within 35 days, for instance, if a prosecutor determines there's a legal error here, this person doesn't meet the criteria, they can e-file an objection with the court, and that case will be routed out of the automatic process over to the petition-based process. If no objection is filed, if prosecutors don't say anything, and we just move on, and we get to the judicial order stage. So because Utah is part of the FBI compact, and I won't get into what that is, but I'm happy to talk offline if people have questions about that, we get to the judicial order stage. So we need judicial orders for every record to be cleared in Utah, because Utah is part of this compact. There is a way to sort of automate this step. So if prosecutors don't object, then an order is going to be automatically generated by court clerks, and a judicial signature stamp will be put on that order. Orders with the judge's signature will then be sent over to BCI, or our state repository here in Utah, for clearance from the person's criminal history. So once it gets from the courts to BCI, pursuant to the judicial order that BCI now has, they will remove Clean Slate eligible cases from a person's criminal history record, so it doesn't appear there. So the courts will take it out of the court system, BCI will take it out of the criminal history, and then BCI will notify all law enforcement agencies, corrections, and other record holders throughout the state that there's a judicial order that requires expungement, that it's going to be removed from the criminal history, and that it also needs to be removed from all of these other databases. So that's our process from start to finish. Happy to answer questions. I don't know if it makes sense now or at the end.
Thanks, Noella. At this point, I wanted to go into a little bit of detail about decentralized courts, and I'm sure folks can come in at the end in the Q&A section and ask any questions about Utah or any of the other topics we cover here now. But for now, one of the things that we've heard has been a hot topic in these webinars has been decentralized courts and the challenges they may or may not impose on passing clean slate legislation and automating expungement. So the first thing we see when we approach this problem is from the outside, it looks very large. It looks almost insurmountable. And I think one of the reasons for that is that it appears to be one problem multiplied by however number of counties or courts systems that you have in your state. And I think that can be a misnomer. And what we try to do is ask the question, what is it that makes this effort with decentralized courts more complicated than with centralized courts? And really dig into what the challenges are and figure out whether or not it's as complicated as we make it out to be. So similar to the conversation that Shayna talked about earlier in terms of the two steps that we look at in terms of automating eligibility and updating records, there are these two components to automating expungement that break down into how do we determine eligibility and then how do we update the records. And so part of what we look at when we talk about this being potentially more complicated is on the determining eligibility side, we may have to aggregate court records for eligibility determination. So there we are looking at however number of counties, whatever number of systems we're working with, aggregating that information in order to have a complete set of data for determining eligibility. And then the second part is similarly the number of different systems, different court systems that need to be updated when we talk about sealing, ultimately sealing or expunging that record. And on the first point, the idea of how do we determine eligibility in a decentralized state, the first question I usually ask is, can we start with the criminal history repository? Because there already exists a statewide database of all arrests that can be used for eligibility determination in pretty much every state in that criminal history repository. Now, it's not always perfect. There may be gaps in disposition reporting. There may be challenges linking records with the courts, with state identifiers, and there's often the challenge of handling lesser charges, those non-fingerprinted charges, misdemeanors and infractions that may only exist in the court systems. And I think the important question that keeps coming up as we've approached multiple decentralized states has been, has someone already solved this problem? Because we're not the first folks that are going to run into this challenge. And 9 times out of 10, we're not the first people who have at least tried to solve the problem. And so we've seen a couple of different scenarios in one where basically there is some sort of data warehouse that collects all of the court records into a single unified space. And we've seen that done in the courts, maybe through the Supreme Court or the administrative office of the courts, where they're gathering all this information, maybe with nightly feeds from all the different lower courts, and aggregating that data all together. And we've also seen in North Carolina, they are not a decentralized state, but they have created a project in their Department of Information Technology called CJ Leads about 15 years ago that pulls together information from all over the place. So warrant information, jail records, court records, prison records, sex offender registration, handgun permits, into this neatly tied up set of information that can be used for eligibility. Now, that's a lot of information that's really nicely tied together that you may not always have access to. But in most of the cases, you will have some sort of centralized information, definitely with the state police, very likely with the courts. And one of the things, to keep in mind, we were working in one state on legislation for a state with over 200 counties and expecting challenges to be proportional to that. But what we found out is the state had already faced this problem and had already addressed it. So someone had created in the administrative office of the courts a thin layer of centralization that allows the county courts to check whether or not a charge has already been expunged statewide. And that's a pretty big deal for passing automatic record clearance legislation. And it's also something that's pretty hard to know unless you're having the right conversations. Unless you're talking to different agencies and different individuals, shadowing court clerks as they do expungements, talking with the IT director or CTO for the courts. So I think it's just important to note that a lot of times these problems have been faced and solved, and it's just a matter of finding the right people to understand how the system works to provide different options. And in the absolute worst case scenario, this isn't a scenario that we've actually seen yet, a state that doesn't have any sort of centralization, even though they're decentralized, but it's possible. And I just wanted to talk a little bit about how you would approach this problem in a situation where there is no centralized source of court information. And this is my hypothetical state here of 70 different counties, post gerrymander reform, it looks like. And in this situation with 70 different counties, it's easy to look at this as a problem times 70 in terms of how we deal with automated expungement. But what we often find is, and this is based on an actual example from an actual state, there are only 7 different case management systems that are being used across the state. And 2 of those case management systems, 2 of those vendors cover 60% of the state's population. And so when we're looking at this, it's important to focus on maximizing what we can do with the minimal amount of effort, and I'll get to that in a moment. But one of the things that when we talk about decentralization, I think another important question to ask is just how decentralized are we? Because these are 2 different state scenarios. In state A, we have a state where 76% of the state's population is covered by 3 separate case management systems. That's a state with over 50 counties. And then we have in scenario B here, a state where 79% of the counties are all on the same exact case management system. And that's a state that has passed clean slate legislation. And so it's important to note that it's kind of like Shayna said earlier about centralized isn't a binary. I think the same thing applies for decentralized states. It's you have to ask this question of just how decentralized are you, getting down to how many different systems contain the data that we need for determining eligibility and updating records. And then the last thing I'll say on this is just, it's important to focus our efforts to maximize the amount of impact with the minimal amount of work. We're working with legacy systems. We're working with data that's spread across a lot of different systems. And in a lot of cases, the work of clean slate legislation is about compromise. It's about figuring out across these hundreds of different systems, across agencies and county lines, bringing it back and focusing on what it is that we're trying to do, what is the impact we're trying to achieve. And ultimately that is, again, coming back to helping people get housing, education and employment opportunities that are otherwise unavailable to them right now. And the how of that is by minimizing what shows up on background checks. So when we focus on updating records, we focus very definitively on where background check companies go to get their data, because there are, as I mentioned, a ton of different actors and a lot of paper and a lot of different data that's involved in the petition-based expungement process. We're not talking about updating sheriff systems or public defenders systems or DA systems. We try to ask the question of whether or not that's necessary and can we simplify the problem. because those aren't the agencies that are sharing that data. And so we try to focus our efforts when it comes to updating records on those agencies that are actually sharing data with background check companies. And as you might expect, that comes back to the same two places we talked about in the beginning. It tends to be, and this isn't true in all cases, but it tends to be some combination of the criminal history repository and the and the courts case management systems, where that data that is being sold in bulk, digital data being sold to background check companies, that's where that's coming from. And so that's where we focus our efforts of updating records in order to scope that problem down. And as we were mentioning before, we can often cover 70 to 80% of the population of a state with just a couple, like 1 to 3 vendors, when we, even in a decentralized state, if we focus our efforts there and we look at what's being used by the individual courts, you'll find in most states, 1 to 2, maybe 3 counties are accounting for the vast majority of expungements that are being processed, the amount of cases that are being processed. And so when we approach this problem, we're trying to make sure that we're not letting the perfect be the enemy of the good. We want to, we don't want to say that we can't pass clean slate legislation because 2 counties that process 5 to 10 expungements a month can't be equipped for automation or for batch updates. In a lot of cases, it's a completely viable solution to export a spreadsheet of cases that need to be flagged as expunged for smaller volume counties, or in counties where you may have legacy systems that just can't be updated. And then the last part here, just to mention, is you can't automate paper. So a lot of conversations we've had in different states are about manual sequestration of files. And we bring this question of automatic record clearance back to what problem we're trying to solve. We're trying to make sure that bulk digital records being sent out to background check companies are being reduced based on Clean Slate, and we're less interested in the physical paper. So we're not talking about manually sequestering files. We're talking about flagging the digital records, maybe de-indexing them if there's situations where people come into the courts to access those records, if that's possible, but nothing that should stand in the way of being able to pass clean slate legislation. And then lastly, this is another concern we hear a lot. So I would just say, you're not alone. It's a pretty big club, and it's pretty rare that we hear someone say that their data is good or great or perfect. And there are some things that we can do to help improve data quality. But a lot of the time when we're evaluating clean slate feasibility, we're trying to scope legislation to work with the data that's consistently available in a computer readable format for determining eligibility. And a lot of times these are just small tweaks to the law. It could be the difference between changing a release date from prison, which may not be consistently available in the criminal history repository, to a sentencing date plus max duration of sentence plus some time window. So it's a lot about being creative with the data you have, using different information as proxy for other information that you may not have, and to remove data quality or data consistency as the solitary barrier for not being able to do clean slate.
Yeah, I think to bring it back to our earlier point on this, it's really important to think about writing policy that acknowledges the limitations of the systems, and not just trying to recreate the petition-based process on the computer. focusing on policy that's implementable and also impactful. So some tips that we have, as Mike said, don't let the perfect be the enemy of the good. You want to start with the most comprehensive centralized set of criminal history data that you have. So depending on your state, this might be the courts or it might be the state police. You want to accept the limitations of the data in these systems. Every state has different challenges with their data, and that's just kind of unfortunately something that we have to acknowledge and sort of move on and think about how can we be as impactful as possible as we design this process. And then thinking about designing the policy to really reflect what's feasible in terms of the data that exists and the systems that you have access to when we're thinking about making an automated eligibility determination. And one other thing to consider is that, of course, you're not going to be able to catch every single case. And the good news is you still have the petition-based process as a fallback. So that process isn't going away. And it's certainly a really important thing to have in our back pocket when we think about how we would automate any eligibility. Thank you so much. Over to you, Sharon. We'll open it up for questions.
Excellent. Thank you, speakers. As predicted, questions have started to come flowing in already after Noella talked about how CFA played such an important role in Utah. So the first question is, did the state pay CFA to do this work, or how is that work paid for?
I can take that one. So we are funded by the Clean Slate initiative, and so the work that we've done in Utah so far has been at no cost to them. And it's been part of our effort to reach our North Star of clearing all eligible criminal records in the country.
Next question. What was it like to get CFA to get CFA access to the state's criminal record database in order to write the code? I imagine there may have been some resistance secrecy by the state agency. It sounds like a good question for Noella.
Sure, I can take this one, and then Code for America can talk about the data sharing agreement and any back and forth they had with the general counsel. Agencies, in my experience, both the courts and the repository, are always freaked out when it comes to sharing criminal history information or records with anyone. That being said, I feel like once our law was passed, and I think COVID kind of helped in this way, like the courts were unable to do this work themselves and knew that they needed help. Code for America was offering help for free. And I think in the judiciary, through my work on the campaign, we really had buy-in from a key number of judges and the Judicial Council and the Administrative Office of the courts. And that was key to making this work. So lots of things were said, lots of fear, but at the end of the day, there were enough people saying, this is something that the courts want to do. This is a huge access to justice problem. People share data for all different types of reasons. We sell our data to private background check companies. It is okay to give Code for America access to this data to do this work. It will be governed by a data sharing agreement. Confidentiality and security will be in place. And so that's sort of what I did on my end. And then Michael can talk about, from his perspective, just that data sharing process or anything he wants to add.
Sure. I think one of the things that we find, access to data is a bit of a back and forth and a waiting game in some cases. And I think we see two different types of states. We see open record states where it's surprisingly easy to get access to data, and we see other states where they protect it and hold their cards pretty close. It really tends to sit on one side or the other. I don't know, Shayna, if you've had any other experiences with that.
Yeah, so especially on the court side of things, obviously getting access to the criminal history repository usually involves more back and forth and a closer data sharing agreement. But yeah, a number of different states have actually opened portals where anyone can research, use the case system, the case management system as a research tool, and they often will allow organizations to actually purchase the data in bulk. So it is something that we're seeing in a number of different states where we've worked.
One last thing I would add as well is that there's states where we've had to actually pass legislation to get access to data, and we've done that.
I would just add that I know that CFA has, in some states, gotten involved very early in the process. Like in Michigan, I think you guys were very intimately involved in helping the state figure out feasibility, right? So it's not just a matter of coming in at implementation time. It may be that CFA was key to convincing all the stakeholders that the legislative proposal was doable. Does that sound fair to say?
Yes, I think one of the things we do is impact analyses early on in the process. So we often get access to data even before we're talking about doing any implementation work, just to help run different scenarios to look at the demographic and geographic impact of policy choices.
I think I just add one thing to that. I think that impact analysis work is so great and could just develop trust, because that's what we're really talking about here is relationships and trust. And if you can have a relationship where Code for America takes a small amount of data and just shows the possibilities to the court and can assure them that they can handle it securely and professionally, that goes a long way, I think, with these agencies. So just wanted to add that.
Thanks, Noella. All right, next question. How does this process accommodate for adjustments in eligible offenses that come through later legislation? Is this something CFA offers as follow-up consulting?
So we're still pretty new in this. We are working through a part of what we try to do is also, and part of Code for America's general belief is just empowering government to do it themselves. So right now we're working through that phase in Utah of now how do we do a handoff of the work that we've done, and how do we make sure that they are enabled and empowered to be able to maintain that moving forward as legislation does change. So it's certainly something that we're in the process of doing right now.
And would it be fair to say, Michael, that once kind of the infrastructure is built, so once the system that I've described in terms of going to the prosecutors and back and forth between the court and BCI and the main code to determine eligibility is written, if you expand to add particular offenses, those are like much easier fixes and could probably be done pretty easily by the court without CFA's involvement.
Yeah, absolutely. It's very minor compared to the big push of infrastructure you have to do upfront to enable Clean Slate.
And I will add that in Pennsylvania, we're already have passed our second bill. The second bill is going to basically eliminate court fines and cost as a barrier, excepting for restitution. So that's a little bit of tricky programming. But as our friends at CFA have also always pointed out, if you have the data, virtually anything can be programmed, no matter how complicated it sounds. It's just a matter of writing a query. I will mention that in Pennsylvania, we managed implementation without any external support. The Administrative Office of Pennsylvania Courts already had a great tech staff who basically figured it out for them. The state police in Pennsylvania did consult with Unisys, I think, to do some work, but the majority of work was done by in-house tech folk at AOPC. So as much as I adore our friends at CFA and they've developed a lot of expertise here, they're not strictly necessary to make this work. So maybe your state has already got the resources in-house. If not, there's our friends at CFA. Okay, next question. Oh, I'm sorry, go ahead.
About that, I would describe the process in Utah and just the way CFA approaches their work as very collaborative. So it wasn't a situation where Code for America just was given all the data and then just gives it back at the end. They came out to Utah, sat with the IT staff who was going to be stuck with this at the end. They mapped it out together. They planned together. Every step, there's high consultation and collaboration with government. And that's one of the things I really like about CFA, because there's this commitment to making sure the government understands at the end of the day the work product and knows how to use it and update it when CFA is gone. And I would say that distinguishes CFA from a lot of like IT tech consulting companies I worked with at the county who would do these amazing things, but then deliver these products that no one knew how to use or update in the future.
The next question goes to the question of how a state can get access to these resources, both at the Clean Slate Initiative and at Code for America. The question says, how do you pick the states you work on as an official Clean Slate state with all the funding that goes along with it? We have a bill pending in our state to automate sealing for a second time, but have not been able to connect.
So I would say definitely reach out to us. We can provide the contact information for one of our program directors, Aaliyah, to get the conversation started.
So specifically, Shayna, would that mean to email Michael or you, and then you'll take the contact from there?
We can probably drop the Aaliyah's. It's Aaliyah at Code for America. If I can figure chat out, I can drop it in the chat.
Or Jessa, can you drop it in the chat for folks? I think we can take care of that, Michael.
Okay.
So start with Code for America, and they will try to take the next steps. Next question. How have places that have automated relief provided notice to individuals who have received automated relief? Noella, do you want to talk about your plans, or should I talk about Pennsylvania or Code for America? Well, why don't we each take a go? Noella, what are you planning in Utah?
Yeah, so this is tricky. So our bill in Utah, our original bill actually had a direct notification requirement that when people's records were cleared, we were going to try to mail out notice to them at their last known address in the court system. As we started digging into those addresses, the problem was nobody had any confidence in them. A lot of them were apartments, some were 15, 20 years old, and this mailing notice requirement was driving up our fiscal note. And at the end of the day, we had no confidence we were going to reach the right people. And we're talking about super sensitive information here. We tried to get creative, contact the driver's license division, the tax commission. Does anybody have good addresses for these people? Nobody was more than 30% confident that they had the right addresses. So we just removed that from the bill because this was right in the middle of the session, and decided we will figure out notification later. Well, now it's later. And we are trying to figure out notification. And so Sharon's been really helpful to show me what they've done in Pennsylvania. And if you haven't had a chance to check out Pennsylvania's site, I think it's worth looking at. We're doing something similar in Utah with an added layer, I would say. So we're designing a website that provides information to individuals about who qualifies. And then we're also partnering with Code for America to develop a tech tool where individuals can come to the site, verify their identity, because we don't want this to be abused. And then once we can be sure that it's the person, this tool will tell individuals information about their record. Noella, you have one felony from 2010, it's a drug possession. Here's the disposition. You have 2 misdemeanors from 2003 and 2002. You know, good news, those misdemeanors are clean slate eligible or have it automatically cleared. We're going to have to figure out the logistics of this. And that felony is still on your record, However, you can get it off your record through the petition-based process. And here's some links to some resources to get that process started. So that tool is sort of the next phase once we actually implement the law, to work with Code for America to design a product that can tell individuals whether they've benefited and also help them understand how that has changed their legal rights. This is going to be particularly important in the case of partial records. So it's easy to say either your record is fully cleared or not, but there will be some people who will be clean slate eligible who will still have other records that are not. And so helping them to understand that, what their options are, and what the petition-based process requires for them to get all the way through the process is going to be a really important component to people understanding this law. Because right now, there's so much confusion. I get emails and phone calls every day, even though the law is not gone into effect yet, saying, you know, my son has a record, does he qualify or not? And it's complicated. So that's what we're doing in Utah. It's very much a work in progress. And then we're pairing that with a public education campaign. We're doing videos and stuff for social media, and I'm working with a group of about 50 grassroots organizations all throughout the state who have touch points with people who might have criminal records. And so as the law goes into effect and we develop all these materials and we have the website and the tool, hopefully in July, August, all of that will come together and we can direct people to this site, which will have all the information they need to know about the record.
And rather than the rest of us answering this question in any depth, although we could talk about this probably in a whole webinar, we have a lot more questions, so I want to keep rolling along. I will add to what Noella said that one of our lessons learned was we came up with the URL mycleanslatepA.com. I think it's really important to have a URL that rolls off the tongue so that you can tell people where to look. You can put it on placards and you know, people, the governor walks around the state and talks about mycleanslatepA.com. So that's lesson number one, pick a good URL. Okay, next, these are great questions. Brenda Smeaton, our friend from Georgia, says, Noella, could you talk about the role of the prosecutor in an automated system? I was surprised to hear they can object. What does that look like in practice due to potential volume? Good question.
This is a great question. So we were really trying to have no prosecutor objection as part of our process at all, because it just complicates everything. It's complicated technologically. As Brenda points out, you have volume concerns, but our DA Association was hell-bent on having an opportunity to review these cases. And so while that is practically in our law, I don't think it's really practical in practice. DAs are going to get thousands and thousands of records and only have 35 days. And so the way they conceptualize this, and we spend a lot of time with the DA Association, is just sort of, they're going to open this file and just look for terrible things. And if they see nothing terrible, then they're just not going to do anything and it will move forward. That's how I think practically it will work. Some of the rural counties that have fewer cases, it gave them a lot of comfort, because I think a lot of those prosecutors are maybe not on board with expungement at all. And so this idea that they're going to get their 5 cases and they can sit and look them up if they want and see if they meet the criteria, great. The objection rights are limited, they're objective, it's mostly just based on errors, and is a check that was needed to get our law passed, but I would not be surprised if it comes out of the law later, because I think it's going to be more annoying to the prosecutors than anything else. So we'll have to talk more offline.
Actually, in Pennsylvania, the DAs were clear they wanted nothing whatever to do with a responsibility to look at the cases. And that was before it turned out that we've had 36 million cases sealed. So you're right, Brenda, realistically, they can't do it. All right, next question. have the courts or other relevant entities actually been able to effectuate meaningful automation? Pennsylvania would say yes. So we're the first ones to actually do this. Utah will be second. And I will say that there's nothing whatsoever in how Clean Slate has worked in Pennsylvania that's raised any red flags in terms of the implementation. We can quibble with the courts about whether they're getting all eligible cases. We would like to see them do this much better, but really it's working great. Next question is, has automation legislation in other places provided funding to courts to effectuate the relief?
I would add just one thing here. There are situations where there are certain grants that can be applied for data cleanup work. We've tried to encourage in different states to do that. There's money out there in terms of these grants, that federal grants, if they can do some work to clean up the data.
So in Utah, I can add that we were able to use some JAG funding for that purpose. So part of it is just taking a look at what grants you have now and whether this might fit within it. I think there's also a federal bill out there. I don't know if it's landed yet. Sharon, do you know the status of that?
I don't know exactly the status, but I think there are high hopes for it. Essentially, it would provide funding from the federal government for states to implement Clean Slate. So that's a really worthwhile federal bill that we hope to see moving. I will say that in Pennsylvania, the cost of Clean Slate was really minimal based on how we designed our proposal and how our automation was already set up. We have a little paper on our fiscal notes and our costs if you want it. Tell you what, we'll circulate that little paper as one of the materials coming out of this webinar. Okay, next question. Do you have suggestions or resources for getting these laws passed? We're dealing with a lot of criminal law reform pushback in West Virginia's legislature right now.
I think just super briefly, what I would recommend is getting law enforcement and prosecutors on your side if possible. And in Utah, we also leverage the support of the business community. Our statewide chamber was very supportive of this as a back to work initiative and a way to diversify the talent pool and a great economy. And those two things, having all of those people on the yes column, really made the no column look small. I know that's easier said than done, but those two groups were key in Utah.
And we just got a note from Jesse at the Clean Slate Initiative saying, feel free to share my contact information if any audience members want to be connected to in-state advocacy partners or involved in the legislative work. Jesse at cleanslateinitiative.org. That's pretty easy. I think Jessa may have dropped that into the chat as well. All right.
You can my contact information too. I'm happy to talk more to anyone offline as well.
And let's see. What else might we have? Is it possible to have the court issue an order that individuals can obtain and potentially show to background check companies if those companies are erroneously reporting dismissed convictions? The answer is yes, because we're doing that in Pennsylvania. Even though most of our work is done by mass orders, you know, that the judge signs an order covering, you know, tens of thousands of Philadelphians at one time, you can get an individual order that you can have for your own as part of the automation. And as for background check companies doing the wrong thing, I would say that what we have going for us in Pennsylvania is that we have a very good process already. We call the life cycle file, in which basically the state notifies the people that buy their bulk data that they have to eliminate the following names and cases from their databases. And that has been working extremely well, even though we're talking about 36 million cases having been eliminated. So it's doable. If you want to talk about life cycle file, we're happy to do that. And if you want to talk about Fair Credit Reporting Act, where these background checkers are reporting things they should not, we're going to do that on one of our upcoming webinars. Okay, next question. Is there anything to prevent just blanket objecting on any automatically cleared case? I think that's addressing our friends, the prosecutors. Is that something that you faced, Noella? Blanket objections potentially?
Blanket objections are not allowed. There's specific purposes that are by statute. That's what they wanted, of course, but then we knew we would see blanket mass objections to just automation in general. So we have spelled out by statute the types of objections prosecutors can make, and most of them are based on things like legal error. There's a problem here, the code didn't work, and so we got to filter this out. And they do have to be e-filed, they have to be in writing, and they have to be specific, or they will be rejected by the court.
Awesome. All right. Have you encountered, or how have you overcome concerns from courts, clerks, law enforcement around unfunded mandates stemming from a push towards automated record relief? Anyone want to address that?
I can just share that in Utah, having Code for America's help has helped with that. There will be either, well, there was some funding under our fiscal note, and then there was technical assistance and support from Code for America. Because we're centralized, we didn't have a lot of issues with the counties. I have worked in states where that are decentralized, where this has become a big issue. And so my advice would be just to engage, particularly those 2 or 3 largest counties up front, so you don't get into a situation where you're running a bill and you have the counties association coming and saying this is going to cost $1 billion and it's not feasible. The more people you can bring in at the beginning and get on your same page, the better.
And I would just echo that. I mean, the district attorneys, the courts, the local, the state police are all really important to get involved and engaged and buy in early on in the process.
Yeah, I really think that's the first thing you need to do almost. We had meetings with the state police and the courts early on in the process, which really cleared the way for our bill to go forward at all. If they had said, this is not gonna work, this is gonna cost a fortune, it would have sunk, because we sold that bill actually as being an efficient bill and an inexpensive one. It really has only cost a couple $1 million of mostly in-house staff to implement in Pennsylvania. The fiscal bill was, the fiscal note was very low. And a big part of that was that we designed our proposal around legitimate objections that the courts and the state police had. We listened to them, we accommodated them, and at the end of the day, they had no reason to object anymore, because, you know, it wasn't going to be that difficult. And in fact, you can also sell this as something that cuts other costs that are involved in the expungement process. Part of what made Clean Slate appealing in Pennsylvania was that the number of petitions being filed was growing and growing and growing and growing, and that had a lot of cost to all of these agencies as well, to do a lot of data input. So this way, it's much less costly per record cleared to do it through automation than it was to do it the old-fashioned way. So that's also a topic on which we can share more information if you'd like it. Go ahead.
I would just echo that. When I called Sharon, that was the first thing she told me. You got to meet with the agencies, which seemed weird to me as somebody who works on other campaigns where, why do we care what the state agency thinks? The distinction between those and Clean Slate is that it's vital, because there will be just, this isn't feasible, it can't be implemented. And if you show you really care, take time to shadow the process, understand how they're clearing records now, work with them to develop a system that works for them, it will go a long way and will prevent heartache in the future. So do it. It was great advice, but it's really, really important that you spend that time.
Yeah, it's just a very different bill, and implementability is crucial, because if you pass a bill that sounds very progressive, but that can't be implemented, it's just going to cause chaos and really undermine the Clean Slate brand, which looks at what is feasible. All right, I think we finally got to the bottom of our bucket of questions, at least I hope so. Thank you to all of us, including those of you who stayed late. I hope we've answered all of your questions, and thank you very much to the speakers for doing the work and answering the questions, and maybe they'll be working with you sometime soon. So thanks all. Hope to see you again soon this summer.
Thanks for having us.
Thank you.